participants. I request Honorable Principal of the college to preside over this function. Chief guest and resource person of today's webinar is respected Dr. M. Betkar sir, Principal of Shri Kumarswami College, Ausa. It's indeed our honor that Dr. M. Betkar sir joined us on the virtual platform as the chief guest and resource person. Firstly, I would like to request Head of the Department of Botany, Dr. C.S. Swami sir, to deliver the introductory speech of this webinar. Please, sir.
Good afternoon to all. President of this webinar, respected principal of this college, Dr. J.S. Dargar sir, chief guest and resource person, Dr. M. Betkar sir, principal Kumarswami College, Ausa, vice principal of our college, Dr. S.S. Bellali sir, special invitees, principal Dr. S.P. Gaikwad sir, principal Dr. Sriram Solunke sir, principal Dr. Bumrella sir, principal Dr. Nathani madam, principal Dr. Satputre madam, my colleague and friend Dr. Alne sir, coordinator of this webinar, and my colleague Dr. M.K. Gurme madam, participants from sister colleges, teaching and non-teaching staff of our college, ladies and gentlemen. At the outset, on behalf of Department of Botany, I welcome all of you on occasion of this webinar on intellectual property rights. I think the theme of the webinar is of current relevance and interest because the intellectual property has assumed a vital role with the rapid pace of technological, scientific, and medical innovation that we are witnessing today. Therefore, it is important to gain greater awareness and knowledge of various issues which are related with the intellectual property. Intellectual property rights are the rights over the creation of the mind. They include patents, copyrights, industrial design rights, trademarks, geographical indications, etc. They give the creator an exclusive right over the use of his or her own creation for a certain period of time. It allows the people to benefit from the information and intellectual goods they create, and also to protect the ideas and prevent copying. This gives economic incentive for the creation, which leads to the stimulation of innovation and ultimately progress of the country. In this context, in order to have discussion on all the related issues of intellectual property rights, this webinar has been organized by us. This will provide the participants with a wide perspective and in-depth knowledge in intellectual property to enable to get solid grounding in the legislative framework, practice, and procedure of intellectual property protected through patents, trademarks, etc. For this webinar, we have invited eminent resource person, Principal Dr. M. Betkar sir, who is having practical experience of patenting the ideas. He has 7 patents to his credit. He has been invited at various places and he has delivered many talks on this particular issue. Today, Dr. Betkar sir is with us and he is going to share his experience and knowledge with us. I am sure his presentation will throw light on different issues related to intellectual property rights and will be definitely beneficial to all. With these few words, I once again welcome you and conclude my introductory speech. Thank you, one and all.
Thank you, sir. Thank you so much. Now I request the coordinator of this webinar, Dr. M.K. Gurme ma'am, to give introduction of invited guest. Please.
Good afternoon to all of us. It is now time to listen our chief guest and resource person, Dr. M. Betkar sir. Before it, I am profusely elated to take an opportunity to introduce our chief guest, Dr. M. Betkar sir. Dr. M. Betkar sir, currently working as a principal of Shri Kumarswami College, Ausa. He completed his research work in the subject of physics. He is having 30 years of teaching experience. He has published more than 75 research papers in national and international level journals and also published a book on simple steps in SSR preparation. He has given 2 presentations at international conferences. He also addressed as a keynote speaker in international conference held at Singapore in 2018. He filed 7 patents and he delivered more than 150 invited talks on patent systems in India and NAC process. He got various honors and awards such as gold medal in Avishkar, state level inter-university research competition, best principal of the year 2018 from IASR Kolkata, and best teacher award from Gurukul Dream IAS Center Solapur. He is the member of editorial board and he delivered 5 speeches on All India Radio on the occasion of Science Day and other subjects. Sir, we are privileged to have you today with us. Thank you so much.
Thank you, ma'am. Now I request the president of today's webinar and principal of our college, Dr. J.S. Dargad sir, to deliver his presidential address. Please.
So good afternoon to everyone. Our respected chief guest and the resource person of this webinar on intellectual property right, Dr. M. Betkar sir, the principal of Kumarswami Mahavidyalaya, Ausa, the HOD of Department of Botany, Dayanand Science College, Dr. Swami sir, the coordinator, Dr. Gurme madam, their colleagues, all the faculty members from our college, and the different participants from different colleges of Dayanand Education Society or neighborhood colleges, delegates, students, and friends. So in continuation with the webinar series, which we are organizing, because yesterday we have also inaugurated one national level workshop in the subject of basic bioinformatics. And that is today also some of the session also going on from the Department of Microbiology and Biotechnology. And now this webinar is organized by the Department of Botany. So in the beginning, I congratulate to Dr. Swami sir, Dr. Gurme madam, for taking the initiative to organize such an innovative webinar, particularly for the teaching and non-teaching staffs of Dayanand Education Society, Latur. And particularly the resource person of this webinar is an eminent expert in such a field Dr. Betkar sir, continuously he is organizing, because we used to see every day. He used to organize for different colleges, institutes, not only in Maharashtra, but also from different corners of our nation for different institutions. So he has a very good knowledge in such a field of intellectual property rights. Intellectual property right, this topic which we have chosen, no doubt, it is an innovative topic. We used to organize different conferences, workshops, seminars, as far as our subject is concerned, or as far as the curriculum of the university is concerned, or as far as the research topics in which we deal is concerned. But particularly this topic, it must be new during last few years to our faculties, or particularly for non-teaching staff. It is also included one of the major theme in the process of NAC, or we have to fill in the SSR of the NAC. Particularly, the questionnaire is there. How many conferences, seminars, workshop organized under IPR? Means it is a needed, most needed, I must say, intellectual property right. This theme, it should be understood by the intellectual, all intellectuals. So for that purpose, because no doubt the different intellectual property rights, the trademark, copyrights, patents, geographical tagging, etc. So we know the property. Whatever we visualize our own investment, maybe the buildings, maybe the field, farm, the visualized the things, that property which we possess, but it is an invisible intellectual property right, is an invisible thing of everyone. I'm getting calls, so I'm getting disturbed here. So it is an invisible. So everyone has his or her own talent. And whatever the creation, by using the talent, that created thing, it may be in the form of art, design, or any type of architecture, any type of patent related to the research and development or technology based. So that belongs to that own individual. There are, because again, this is a vast field. And from the beginning of our Constitution of India, or worldwide, when we think about this topic, so different laws have been made so that everyone, talent, intellectual must be protected, and everyone gets an opportunity to earn by using the intellectual property right. So it's own property, and it has their own rights. So that rights, they are governed by the Constitution of India, and no doubt, worldwide there is an institution, World Institutional Property Right Organization. There are different laws also governed for a trademark, copyright, patent, and accordingly, the laws, they are being revised time by time. So all these things we must know. Everyone who involved in higher education must know for that purpose. Because before that, we have also organized 2-3 times. Mr. Betkar has delivered 2-3 times lectures or his expert thoughts related to this intellectual property right for our institute, for teaching and non-teaching staffs, not only for staffs, but also for students. Students should be aware of all these things. So taking the concept, it should not be considered for the knack purpose, but it should be considered as far as the knowledge is concerned. And as our institute has mission, vision, and motto statements, the motto, Ano Bhadra Kratu Yantu Vishwata. So you know the meaning that let the noble thoughts from all the direction of the world to come towards us. So this is one of the noble thought of IPR, which we are gaining via this webinar. So everyone got this opportunity to understand the more detail about the IPR in future, because as some of our teachers, they are involved in research and development activities. They are publishing their papers at international level with high impact factors. And if you want to put your paper under patent, so you must know what type of procedure is involved there. Regarding that, or with related to such, everyone should understand what is IPR. In future, I think the university can also place some part of the IPR in the curriculum. So it is a needed. So for that purpose, such type of webinars, through such type of webinars, we will understand the basic concept, the basic knowledge, or some more detail about the subject intellectual property right. So I think this webinar will be vibrant because it should not be one-sided. There should be a discussion. Discussion must be there. Interaction must be there, along with the resource person, not only resource person, because in this webinar, some of the eminent faculties also join. They must have their own knowledge. So there must be an interaction. So it should be a vibrant, productive, informative, inspirable, motivable. So all these things we shall get by organization of such webinar. So once again, I congratulate Dr. Swami sir and his team. So all the departments, they are going to organize different types of workshops, seminar, conferences, as it has been allocated by our IQAC in the strategic plan. So I think this month will be the organization of series of such type of seminars, workshop, or conferences. So everyone, not only our faculties, staffs, but also the other faculties from different institutions will get full of knowledge in the field of higher education, research, and etc. So I hope this workshop, this webinar will be an informative, and everyone will gain a knowledge from this webinar. I wish a grand success for the organization of this workshop. So there should be an interaction with the resource person. I once again welcome our chief guest, Dr. Betkar sir. He always aligned with me. So during night hours also, we had nearly about 1 hour discussion, telephonic discussion on any topic. Very enthusiastic person and so knowledgeable. So no doubt you will gain a huge knowledge via this workshop. So once again, I welcome Dr. Betkar sir and grand success for this webinar. Thank you very much.
Thank you, sir. Thank you so much for your valuable presidential address. Now, I request today's chief guest and resource person, Dr. M. Betkar sir, to deliver his informative speech on intellectual property rights. Please, sir.
Thank you, Gurme Madam. The chairman of this webinar, respected Principal Dr. Jaiprakash Dargad sir, also member of the University Body Innovative Board. Daily we are seeing the activity of this reputed college, top graded college of our area. I am proud to be that we have a MOU with Dayanand Science College, and this is one of the activity covered under that. Dr. Principal Sir is always, Dargad Sir is always our point of inspiration. He is having his efforts to the academic development of the college, and that's why everyday activity and students' merits, all the reputation of this college goes credit to Dr. Jaiprakash Dargad sir. He is also having a very cooperative nature, and he was a key guide of our NAC process of our college. Thank you, sir. I always interested to listen your speech, and today I get an opportunity to join with you on this webinar. I will try to stand best as per your expectations. Head of Department of Botany, Dr. C.S. Swami sir, organizer of this webinar, Dr. Gurme madam, Vice Principal, Dr. Bellale sir, the faculties from Physics Department, Dr. Thakre sir, Dr. Mote sir, invited principals from other college, Dr. Gaikwad sir, Salunke sir, and other institutes, all the faculty members of Dayanand Science College, and students, and all the participants joined here from all over India. As per the Dr. J. Dargad sir said that this event is not organized by keeping the motto to fill up only for the NAC, but there should be something awareness, knowledge about the intellectual property among our faculty, non-teaching staff, students and teachers, and those who are participated. It's a very related thing to our faculties, because most faculties publish their papers, research papers in the reputed journals with high impact factor, international journals. At the same time, if we think if there is potential of filing the patents or filing any intellectual property from that, it will be beneficial to that self teacher, to student, that college, to institute, all, so that this activity should be always should be continued and to be taught in the researchers. As your college is having so many research labs, well equipped research lab, we all are benefited from this your all laboratories. So the innovative researchers, those who are working with your research centers and the faculties, research scholars, research supervisors, they get benefited if they file to try to create an intellectual property like the patent. So with this introduction, I will start my presentation. Thank you, first of all, sincerely thankful to the management of Dayanand Science College, Latur, principal and organizing committee for inviting me here in the national webinar on intellectual property rights. Let us see the objective of this webinar or my presentation. First objective is to know about intellectual property and intellectual property rights. What are the intellectual properties and what are the rights related to that intellectual properties? This I want to explain here. Secondly, to create awareness on intellectual properties. What are the intellectual properties? How we create them? So this awareness I have covered. And third part is the process of knowing the filing the patents. By listening all these things, someone try. Definitely, I am confident with your staff and participants and students also. They will try to file the patent. At that time, at least they should know the process of the filing the patent. And the students of this college are so lucky that I myself introduced with the patent after my age of 45. But within your age of 25 years, this college have introduced you with this innovative thing, that is the patent. So students, if they get knowledge in this age and while they are learning here in this college, they may file the patent, and it is the best thing for the college and for the students for applying for their future in the career. So the index is what is intellectual property right, what are intellectual property types of intellectual property rights, what is the infringement in the intellectual property, what are the benefits of intellectual property, what are the terms of the patent or intellectual property, what is a patent, what is patent filing process, what are the examples and news related to patent. So all these points I will try to cover in the next 1 hour. And what are the useful websites for filing a patent? This is the index of our next presentation. Let us see on the screen. It's letter I. In the word IPR, I just filtered out the letter I. What is I? I is the thinking, intellectual thinking of a mind. So on screen you are seeing that someone is thinking, and it's the intellectual thing, and as an example she would like to create an electric bulb as an example. So in the intellectual mind, the thinking is related to the formation of an electric bulb. And in the second slide you are seeing that the person who are thinking to think on formation of an electric bulb, now she have created an electric bulb. Then now it is the intellectual property. The property came out from intellectual thinking of mind. Let us see what happens when some innovation comes in the market. Few wrong persons try to stolen their knowledge, try to use that activity, try to use that technique, and try to use that knowledge without consent of that inventor. So these things happen of stolen of knowledge before the registration of that intellectual property. This happens. What happens after the registration? So if we innovate something, if we register that on our name, then we get the right on that intellectual property to the innovator. So what are the intellectual property rights? The rights given over the creations of mind after the registration properly in the proper office. So if there is any property like plot or home, we can't say that this is ours. Once if you have registered it on your name, then you can say that you are owner of that property. Similarly, if you try to innovate something, you try to create something intellectual property, if it is not registered, no one can give you the rights related to that intellectual property. So that the intellectual properties should be registered on the innovator's name in the intellectual property office, so that after that you get the right on the intellectual property known as the intellectual property rights. Let us see, there are two groups of intellectual properties. First group is intangible property, which we cannot touch. That is music, theme of a book, or any idea in our mind. It's the intellectual property, intangible intellectual property. And the next part is the tangible property, where we can touch, like car, bike, motor, all these things. So these are the two groups of intellectual properties. Let us see, after seeing the groups of intellectual property, let us see the types of intellectual properties. And there are 7 types of intellectual properties, out of which let us see the first type. First type is the trademark. Trademark is the intellectual property. It is related to every organization or factory. You are seeing that, or we all see, every product is related with a logo, monogram, and they market their product. They try to create an innovative logo or symbol which is unique one, and it is registered under the trademark office, and then only they get the right for using that trademark for marketing their product. On the screen you are seeing that there are 4 to 5 trademarks I have given as example. That is Amul, the Taste of India, Jack Daniel, Coca-Cola, and Parle-G. All are different. One is Amul with a picture and a slogan. Jack Daniel is a signature gesture and it is also trademark. Coca-Cola is a cursive lipping. It's also trademark, written in a proper matter. And Parle-G with a picture, that is also trademark. If you see the different trademarks, they are unique one, and there is no restriction for creation of the trademark. But once it is created, it should be registered, and after registration, that organization, that factory, that industry get the right to use that trademark, and they market their product under this trademark, packing of this trademark. And we can identify that some product is from which brand it is in market. So there is no restriction for creation, but after creation they get right, after registration the trademarks right. There are so many types of trademarks you are seeing in the market. Let us see the second intellectual property, that is the geographical indication. What is geographical indication? Geographical indication is the intellectual property which is man-made or natural, which is famous or showing identity of that area, and that can be registered under the geographical indications. On the screen you are seeing that Kanchipuram silk sari, Kolhapur chappal, Alfonso mango, Puneri pagdi. Out of these 3 are man-made and Alfonso mango is natural one. So the natural things or famous things, productive things, they are identity of that area and they are registered under the geographical indications. What are the benefits of this registration of the geographical indications in the intellectual property? When a product is registered under or given tag as a geographical indication, it goes on the map of the world. There is demand of that property for purchasing from out of India also. So basically market economic good gets increased. And second benefit is that there are more chances of employment in that area. And third important is that no one can claim that product is from that area because it is registered. Alfonso mango cannot claim that it is from USA or China. Kanchipuram salgi cannot be claimed by other regions. So it is the benefit. Similarly, you are seeing some words, you have listened the words Nagpur orange, Basmati rice, Paithani of Paithan, Kullu shal, Nasik Valley wine, Tirupati laddu, all these Agra Petha, all these are the geographic indications registered by our India in from that area. At present, India have registered more than 600 geographical indications as a proud of our property, and Karnataka state is having highest geographical indications registered 42. So these are the geographical indications. As an example, as you see that there is Nilanga, near Nilanga there is Borsuri Varan. Borsuri Dal, this word is famous one. One can try to file the geographical indications as proud of our area. So the famous products or food products or any product which is famous in our area, we can register it under geographical indications. Let us go toward the third intellectual property, that is the design or utility model. Just the external features, 3D features of any innovative design can be registered under this utility model or design as the intellectual property. There are two pictures I have quoted here. First is some innovative part of a machine 3D model, how it works. It's also design. And second is picture of ornament. If you see, there are famous goldsmiths like PM Gadgil, Pete. They charge so much amount when we try to purchase some ornaments from that shopping. Suppose that there is an ornament having 10 gram of gold in it. It should be priced at 60,000 rupees maximum or 70,000 rupees. But the famous goldsmith like Pete, Gadgil, all the persons try to price that product or the ornament more than 1 lakh. Why this happens? It happens because their design is unique. They have registered under intellectual property, and we have no choice to get the same design in outside the market. So it's the benefit of creating the unique design of any ornament or any creation. This is what the third intellectual property. Let us see the fourth intellectual property, that is the plant's breeder right. As there are so many participants joined here, right from CS Swami sir, Gurme madam, and many students from the botany area, they are knowing the technology of biotechnology technique, tissue culture technique, cutting techniques. So by this, using this technique, if someone innovated some new seed or new plant, new breeder variety, breeding new variety of the plant, and that can be registered under the plant's breeder right, and it can be marketed by the biotechnology seed or any variety of that seed which is beneficial one in the sense of the yield, all these things. So that this, if the product is innovative, if the breed is innovative, that variety can be registered under the plant's breeder right. This is the fourth intellectual property. Let us see the fifth intellectual property, that is the copyright. Copyright is a well-known word to all of us. When we publish our book, when we publish any painting, or when we publish an article in the newspaper, or when you create an audio CD of a song, or when we create a video CD of drama of your college department in cultural activity, or any software app created by you or student, all these comes under the copyright. So you can get copyright with all creations, and there is no need for applying an application for copyright in the office. For legal matter you can apply, but the date of publication of that creation gives your right as a copyright. So there is symbol C, circled symbol C, and there is written that this is the copyright to this institute or to this owner, to this author. So this is the fifth intellectual property. Now let us see the sixth intellectual property. It is the semiconductor IC design. As you are seeing that, as you are and myself is knowing that every innovative product, computer, TV, mobile, all these uses the IC integrated circuits in that, and every integrated circuit chip is having its unique design, applicable design. So that design can be registered as intellectual property, and the equipments which are using such ICs can be patented. So semiconductor IC layout designs are considered as the intellectual property, and any article which is including that IC which is working on that intellectual integrated chip, that is patented one. Now let us see the seventh intellectual property, that is the patent. Now let us define what is patent. Patent is what? It is a monopoly right granted to a person who has invented a new and novel useful article. It is the right given by the government. To whom it gives? It gives to a person. Which person? Who has invented new or novel and useful article. It should be innovative one. That time patent is defined. Secondly, if there is improvement on existing article, we can define patent there also. As an example, improvement of an existing article means, I would like to give here example. As you see the car vehicle, it was firstly running on diesel, then petrol, then CNG, then hybrid, and now electrical cars are in the market. So all these are innovations related to single article car, but at every time it's improved. So every improved engine, every improved design is able to grant a patent. Thirdly, a new process of making an article. What is the new process? If we synthesize something by using the new process, but product is same. Suppose that a product paracetamol tablet. More than 1000 company or industries produce the paracetamol, giving the paracetamol name. But process of synthesis of every paracetamol company is different. So that if there is a process is different, at that time we can define it as to file a patent. And important thing is that the article should be capable of industrial application. Means there is no any patent granted on the imaginary thing. There should be applicability of that patent in the industry. So this is the definition of the patent. Let us go ahead. What are the required things for a patent? Three things are required. One is there should be novelty, there should be innovativeness, and there must be utility of that product. If three things are satisfied, then we can define or file a patent in other fields. After seeing the definition of the patent, let us see what are the patentable inventions. Means every invention is not patentable, but our aim is to know which patents or which inventions are patentable. Let us see in this section patentable inventions. Let us see machine, articles, equipments which are innovative one, other articles which are useful to the industry. If they are innovative one, they can be patented. Number second, if the process is innovative, method of manufacture of equipment or anything is innovative, it also granted for a patent. And number third, if the software is running a hardware, alone software is copywritten, but the software is used to run any hardware in our scientific process. If you use some software to run an machine, so that machine and that software along with it is patented. Three things are patented. Also, the chemicals, medicines or drugs are patentable, because when we form a medicine or drug, at that time we have to mix few chemicals. After mixing that few chemical, there is chemical reaction in between that ingredients, and one innovative product comes out. And every ingredient of that chemical loses its original property. So that chemicals, medicine, drugs, and food products, if they are innovative one, they are losing their original property, they can be patented. After seeing what is patented, it's also must to know that what is non-patentable. If we think an idea and do so many work on that, and if you find that it is non-patentable, then our all exertion goes waste. So that before filing a patent, let us see what is non-patentable. First thing, known inventions are non-patentable. Means those who are published, those who are knowing peoples, that cannot be patented. Known inventions cannot be patented. Second, the inventions contrary to natural laws, those who are violating to natural laws, they cannot be patented. Thirdly, the inventions which are against public ethics and morality, they also not patented. Means those equipments who are keeping product, those who are manufactured by using objective to avoid or to neglect the ethics and morality of our public, that cannot be granted for the patent. Second, those equipments which are based on the objective of the commercial exploitation, they cannot be granted for the patent. Again, the innovations which are harmful to health of human, health of animal, health of plant life, or to the environment, if it is harmful to all this, it cannot be granted for a patent. Means any invention which is made, which have created by keeping the motto that which should be harmful to that human life, animal, plant life, or environment, it cannot be granted for the patent. Discovery of scientific principles cannot be granted for a patent. It cannot be equipped, and it cannot be granted for a patent. It's the knowledge. And seventh thing is, the substance obtained by admixtures cannot be granted. What are the admixtures? Those students from chemistry, those teachers from chemistry, they are knowing that what is admixture. But for other participants, I would like to say something about admixture. Admixtures are such mixtures, maybe liquid or maybe solid. They are together but not reacting in between. At that time, we say that these are the admixtures, and they cannot lose their original property. They having the same property after mixing also. For an example of the juice, if you want to create a lime juice, then you use that extract of lime, then sugar, then salt and the water. If we mix all these things, it gives separate taste for that. But all these parts are mixed. Ingredients are admixtures. They can be filtered out again. So admixtures are not having innovative product, are not having innovative property, so they cannot be granted for the patent. Eighth thing is that the plants, animals in whole or any part, any plant, any animal, any part of any animal or plant cannot be granted for the patent because they are natural. There is no any innovation from our side. So no plants and no animals or any part cannot be granted. But if we extract some part from that tissue and if you do research on that, that can be granted out of the body. So plants, animals cannot be granted as it is, they are not granted for the patent. Number 9, method of medical cure cannot be granted. As like we see that nadi pariksha or any massage or any curing method cannot be granted for the patent. It's knowledge free for the public, for the well health of the public. But the equipments used in the medical sector, in the medical field, as like thermometer, stethoscope, scanning thermometer, thermal scanning thermometer, all these equipments, practical operation equipment, all are granted for the patents and can be applied for the patent. But method of medical cure cannot be granted for the patent. Let us see the 10th, method of agriculture or horticulture cultivation. The method of cultivation of agriculture and horticulture sector cannot be granted. But the equipments if we use in that medical, in the agriculture and horticulture field, that can be granted for the patent. Method is kept free. Now, the traditional knowledge which is with us from ancient age, which is available in our literature, that cannot be granted for a patent. Traditional knowledge cannot be granted for the patent. It is came from our early generations. Now, 12th thing is that atomic energy inventions cannot be granted for a patent. If you want to do some research or innovation in the field of atomic energy, you have to apply for the atomic department of the government of India. If you get permission, then you can apply for the patent or to innovate the atomic energy inventions. After seeing detail what is granted, what is not granted, what is applied for the patent, what is not applied for the patent, let us see what can we do with our IPR. What is IPR? IPR is a certificate given by the government or to our innovation as right. So what can we use? What is the use of that IPR with us, and how that IPR is used, intellectual property rights, how we can use it? Let us see here. IPRs can be assigned for a certain period. As like our physical property plot or any gold or any bungalow or any farm, we can assign this physical property for few years to recover financial crisis. Similarly, if any factory is in financial crisis, or if someone want to take benefit of that intellectual property certificate by assigning to some factory for few years with an agreement, at that time, as like our physical property, intellectual property certificate means intellectual property rights can be assigned for financial benefit. This is the first. Second, intellectual property rights can be sold. Means if you want to sell your intellectual property which have innovated you for the financial benefit, then you can sold your intellectual property on your price. There is no any limitation what you demand. And after the selling of that innovative property to someone, the next person which is buyer of your intellectual property gets benefit from that, but not you. So as like our physical property, intellectual property can be sold. Third thing, intellectual property can be gifted. As our routine life, as we give something to someone, similarly you can gift freely your intellectual property right to someone, so that what the benefit of that intellectual property after the gifting properly, that person who receives the gift, he or she can enjoy the benefits of that intellectual property. So property is intellectual, it is commercialized, it can give so many benefits, financial benefits as per the depth of innovation, as per the demand in the market. So three types of things can be done. It can be assigned for few years, it can be sold, or it can be gifted as like our physical property. Let us see after that few patent examples. I have collected here funny examples, not so hard examples to explain. It gives an idea of simple innovations can be created an intellectual property or then inventions. Let us see first. Hello. Let us see the first intellectual property or the patent registered name as anti-eating face mask. It's the simple mask to avoid a patient to eat something without the permission of doctor. At that time, the doctor uses this face mask for locking the mouth of a patient and keeps key with him. So this is the simple patent which is granted knowing as an anti-eating face mask. Secondly, it's the common example and routine example of everybody have experienced that there is a patent on back scratching machine also. So when we feel such sensations regarding our back scratching, we must think if there is very nice, if there is a equipment for curing this one, for this. So there is equipment on patent which is filed for the back scratching. Thirdly, it is the funny example of an officer. If one officer start to give some instructions to divide some responsibility to the colleagues, at that time they avoid the work by saying some reasons of headache and all these things, or any pain in their fits, all these things. At that time, that officer thought to create an innovative wheel which can cure this and can efficiency of office can be improved. So this is the funny example known as it is the known as the curing headache wheel at the work. So it is also granted for the patent. These are the funny examples, and you can imagine those who are things which are using in your daily life, they can be improved and they can be innovated and they can be filed for a patent. In the next part, let us go ahead to see the infringement. This infringement terms came in intellectual property area, and encroachment terms is introduced in the physical property. If someone have increased a plot for 5 or 10 feet, it's encroachment. Similarly, the encroachment, the word in the field of intellectual property is defined as the infringement. Let us see what is infringement. Infringement is that unauthorized use of any product, duplication of any product, sale of any duplicate material available in the product is the infringement in the intellectual property area. It causes financial damage of that original factory and it is punishable one. So infringement in intellectual property, you always see some read in advertise in newspapers that someone is branding our product which is duplicate one with using our trademark. So you don't be get influenced for that. So similarly, many persons try to infringement in IP cases and it's wrong and punishable. Let us see 3 examples here on the screen. 3 brands having one is original, one is duplicate. Okay, Ole, Colgate, Colgate, Bilseri, Bisleri. So they look similar but not same. One is duplicate and one is original, and the duplicate brand always causing the financial damage of the original brand. This is the infringement in the intellectual property cases. I would like to share an example with you. There was a fine to Samsung company more than $1 billion because Samsung company have copied some crucial features of iPhone created by the Apple, stolen by the Samsung. So in the international court, when it was a stand to case, then it was fined, Samsung company was fined $1 billion. So it's the wrong thing, and one cannot do the duplicate of some product, and duplication of some product, it comes under a crime and infringement in the IP case. Let us see this slide 1 2 ka 4. I would like to explain what is 1 2 ka 4. Means how a single intellectual property or innovation related to other intellectual properties. So it is the 1 2 ka 4. Let us see on the screen. There is a digital FM tuner or portable video player, audio player. It is related to 4 intellectual properties. It should be registered under 4 intellectual properties. The innovative idea of that thing is patented. The 3D design, their switches or the opening, closing, all the model, how it will sit on the table, all these external features are registered under the design utility property, design of that intellectual property. The name which are seeing you on the screen, Philips, which is arrow 1, that is registered under the trademark. And what music you are listening, what video you are seeing from that, that is under copyright. So you might be getting clear idea that 1 2 ka 4 means one product have to be registered very different intellectual properties as like patent, design, trademark and copyright. If you not did one single thing out of this, one can claim your product of that product. So that this is the 1 2 ka 4, that is one patent or one innovation related to so many intellectual properties. After seeing details of the patent patent types, examples, intellectual properties, what is infringement, which can be patented, which cannot be patented. Let us go to the next part towards the filing of the patent. Filing process is should be known to all. What is the first thing? If you want to try file something, you have to write down that idea as much detail as possible. It may be rough, but it should be written as much detail as possible. If you want to try to file a patent on something, you have to imagine about that utility, of that use, of that user-friendly thing. You have to write that idea as much as detail as possible. Also, second part is that you have to check the patentability of subject matter. If the thing is not patentable, we cannot go ahead, our exertion gets lost. So that we have to check the patentability of that subject matter, second thing. And if it is confirmed that the thing is patentable, the invention is patentable, it can be attract buyers or it can be commercialized. If you see that in that innovation, you can go ahead for filing the patent. Now, there are 3 steps before filing the patent. First step is searching, second step is drafting, and third step is sending. What is searching? If you want to publish your research paper, usually you think to search the related literature on the net. Similarly, if you want to file a patent, then you have to search the related patents on the available search engines. This is the first step. Second step, after searching, we have to draft properly in the patent language, Hindi or English. And third step is we have to send the patent. So let us see that the first step is searching. Searching on the net, searching on the engines. Which engines are available? There are so many search engines for the net are available. But for filing a patent, these 5 search engines are sufficient as I think. First is the Google patent, second is the USPTO patent, third is the INPAS, Indian Patent Advanced Search System, fourth is the ESPCC net, and fifth is the WIPO, World Intellectual Property Organization. These 5 search engines can help you to search your most related patents. There are lakhs of patents available on a single invention. From 70 years, data is updated in this search engine. So we have to search the related patents. We have to relate all the patents which are most related to you, 5 to 10 patents, and you have to say confirm that your innovation is different from that, innovative from that, improved from that. So this searching is important. Now, as an example, before few days, I searched a word PEN. Because of curiosity, I write the word PEN in the search engine. I got more than 10 lakh patents on a pen which are using daily in our life, which is in our pocket. So, pen is not negligible. It is improved more than 2 lakh times and it is patented more than 2 lakhs times. So that it's the things which once it is formed, we can go ahead for improvement for filing a patent. Is the simple example of pen which is having more than 2 lakhs of the patents filed on a writing pen. Second step is drafting. What is drafting? As like our paper, there is abstract, title, then abstract, author's name, and then introduction, then research methodology, then calculations, and all the characterization and the conclusion. Similarly, patent is having its own structure. We have to fill up that structure with related information in the special techno-legal language of that patent office. So this is the second step is drafting. Now, after drafting the patent, we have to send the patent to a proper office where we reside. Means third step is sending of the patent. And there are 2 types of sending patent. One is manual and second is e-type. It's very clear that for manual sending, we have to download the applications. we have to fill up the application, and we have to go to courier or post office for sending the application with proper amount of the fees with DD. But without going away from home, this corona period, we don't prefer go outside the home. We are keeping safe to ours, and we are trying to take care of others also. You can file your patents from your home also by e-filing system method. Now, where to submit the patent? There are 4 offices of the patents in the India working under a single roof: Mumbai, Chennai, New Delhi, and Kolkata. These are some judicial areas where our address is there. If you find our city in some area of that proper office, we can file the patent in that office only. But there is no difference for filing in any office. All patents are processed under one roof under the Government of India patent section. Means for our Maharashtra, there is Mumbai, we can apply the patent in the Mumbai office, and for other areas there are different offices. Now let us see the next part. Who can submit the patent application? As our principal sir said that students, teachers, non-teaching staff all are invited here. It's very correct, sir, because patent is not related to only senior lecturers, junior lecturers, non-teaching staff, students, but it is also related to every citizens of our India, which may be literate or illiterate. Literate person or persons which is senior teachers or any scientist from the research lab, he or she at the same time illiterate person also file a patent. So in this section we see that the applicant himself, known as true or the first investigator in the language of patent literature, known as the true or first investigator, can file her or his patent himself by going to visit to the patent office. Secondly, patent can be filed jointly. If some researcher is working with research scholars, if they have contributed for the innovation jointly, they can file the patent jointly. At the same time, if your institute is providing some financial assistance to you, at that time also we can joint our patent with our institute. Those who have read the literature of MRPs, minor research project or major research project, there is agreement. It is written that if someone is filing, we are financing you, and if you are filed patent, filing patent, then you have to take permission of our office because we are a financer, and you have to file the patent jointly. So patents can be filed jointly. Such a literature instruction you might be written in read in the MRP and minor research projects. And thirdly, if you don't want to go to office yourself, then you can issue an assignment letter to a person. Through the assignee, you can file your patent. If you issue some letter, assign letter to him for filing the patent, that person go to the office in absence of you, and you can enjoy at your home or in a picnic, and that person can file the patent. And fourth is that you can file your patent through authorized IPR agent. The authorized IPR agent are not like as our RTO agent. They are illiterate or not so higher educated, but they serve to RTO office. It's not the same case. The IPR authorized agents are the agents, those who have passed the examination organized by the office of the intellectual property office. If they pass, they get the license, and they can help to all persons, maybe literate or maybe illiterate, maybe scientist or maybe teacher, and they act as an authorized IPR agent, and someone can approach to that agent and can file the patent on his name. So illiterate person can also have an innovative idea. He can approach or she can approach to that person and file the patent. And unfortunately, if some person is dead before filing the patent, this happens unfortunately some time. At that time, the legal representative of any dead person can file the patent. So there is no any obstacle once it is written and filed to file the patent. Let us go ahead. Which forms are used? Seeing the idea of filing the patent, where to file, let us see which forms are required for filing the patent. There are 4 forms defined by the Intellectual Property Office: 1, 2, 9 and 80. All these forms are required for filing a patent, for granting a patent. Form number 1 with a fees of 1,600. Form number 2, no fees. Form number 9, request for publication with a fees of 2,500, and form number 18 with a request of examination with the form fees of 2,500. So there are nearly 7,000 rupees are required for filing a patent, and with these 4 forms one can file a patent. Now, after gaining the knowledge about the filing of forms, let us see what are the types of filing of a patent. We have to see what are the types of filing a patent. There are 2 types of filing a patent. One is provisional filing, one is complete filing. What is the difference in between that? For provisional filing, if you want to some fear about your idea, some stolen idea, someone will stolen your idea, and you think that that idea should be, title should be patented, so no one can stolen that idea. At that time, just you write an abstract with form number 1 and with fee of 1,000, you can register your title of the patent with few lines of abstract as a provisional application. But as we submit provisional application, we have to complete every aspect of that patent within 1 year in the complete specification. Means with form number 1, 2, 9, 80 with fees, detailed draft, drawing, sketches, supportive material, characterization. Complete specification of that patent should be filed within 1 year. Then and then only that provisional application come into force, otherwise it gets lapsed. So one can go directly for filing complete specification. There is no need for filing provisional specification. But benefit of filing the provisional specification is that we go to search, or we try to complete that file within 1 year. जसं आपल्याला एखादा जर काही महागाची वस्तू प्लॉट वगैरे घ्यायचा असेल तर काही इशारात रक्कम देतो, 50-50,000 1,00,000 रुपये, आणि त्यानंतर आपण ते घेण्यासाठी प्रयत्न करतोय कारण ही पहिली अमाऊंट वेस्ट होऊ नये. तसं टू नॉट टू लूज दॅट टायटल we go ahead. So this is the benefit of provisional filing, but there is no need for provisional filing. Now let us see that what is the tenure of a patent. Means once the patent is granted, it cannot be a process or it cannot be right for throughout the life, but there is limitation of tenure of any intellectual property. Let us see in detail. Patent is having 20 years of the owner's right, copyright 70 years or up to the liveness of that author creator, designs have 15-year life, and plants bidder right is for 15 years. So these are the tenures of particular intellectual property. After 20 years, that patent goes to the public or the government. We cannot claim any right on that. Similarly, all these things. But the 4th, trademark is such an intellectual property that can be renewed after 10 years. So that you are seeing that there are so many factories which are running from last 2,000 years, 3,000 years, as like Hindustan Lever Company or other. They are renewing their trademark after 10 years. Then and then only they are getting the rights to use that trademark for infinite time. So these 4 properties, above 4 properties, patent, copyright, design and patent, plants bidder right, are limited for a period, but trademark is not limited. It can be renewed after few years. In the introduction speech, Dr. C.S. Swami have said about the tenure of the patent, all these things. Let us see who are the top 10ers, top 10 of the patent filing. China is top in the universe, world, for filing a patent. Our India is at 7th rank. You are having esprit that China products are not durable. They are not having so much life as our opinion is, and it's correct one, they file patent on that product and then they market their product. That may be very simple one, simple from tire to toy to up to the any innovative product they market at first, they patent at first. So there is no relation of quality and patent. First of all, you have to see that their patent is granted for only idea, mechanism or the product. What should be metal there? How should be metal there? Which durable things are used? There is immaterial thing for filing a patent. Patent is given for that innovative idea, creations of that innovative idea. At the same time, the opposite part is that all the patented things are quality one, because if you purchase a medicine from the patented, then it is the highest medicine, quality medicine. So patents are not related to quality, patents are related to mechanism. At the same time, it's correct that patented medicine, drugs or products are highly productive or highly quality material, because in R&D section of that lab they have invested so many amount they can recover by keeping the heavy charges. So that let us see what is the condition of Maharashtra, level of Maharashtra. It is a proud thing is that Maharashtra is topper in our India for filing a patent. So Maharashtra is topper one. Now let us see what about the patent rights. Patents rights are territorial rights. They are applicable only in the country in which it is filed. Suppose I have filed a patent in India, I cannot claim any right if someone is selling or duplicating that product in Pakistan or Bangladesh or in China. So they are applicable in the particular country where it is filed. It's very hard for a researcher to file the patent in every country. But India, government of India have a provision, kept an provision for the researcher for international filing. If someone filed internationally, as per the agreement, the patent right goes to more than 50 countries. So single application, international application, you get benefit from that country, means more than 50 countries. So it's a benefit given by the patent office and government of India. Let us see on the screen, there is a picture. I would like to share a story related with that. The David J. Latur, who is the wild animal photographer, installed his camera in the jungle. At that time, he observed that when he developed the film, photo film, he observed that there is a picture of monkey. He not identified which species was that. So naturally he submitted that picture to the Wikipedia. It's a story on Wikipedia, and Wikipedia naturally allowed a copyright to that David J. Latur. David J. Latur written a letter to the Wikipedia saying that this picture is shooted by that monkey, so I cannot claim or cannot able to receive the copyright on my name. So it's better to give copyright to that monkey. He was not in the listening mood. So case in international court was filed by the David Latur, and US court judgment was that a monkey could not claim the copyright, because if there is a right given to someone, if there is enjoyment of that right, of someone is violating that rule or right, we have to go ahead to avoid that person for violating that right. That monkey cannot do that. So every right is given to the human, because they can go ahead in the next process of enjoying that rights. This is the story. Now let us see few breaking news on intellectual property rights. Which are breaking news? Commerce Industry Minister Piyush Goyal announced 80% fees reduction to all recognized educational institutes for applying patents, whether in India or abroad. So there is 80% fees reduced by the government of India. Also, They have suggested institute for the scholarship to the students which are studying intellectual property law in the India. Also, there are reforms or patent filing process which made more easy, user friendly by the patent office. Also, intellectual patent there are award by the government for the institutions those are filing intellectual property rights, and the simplified IPR process is also done by the government. These are the initiatives by the government. Also, one thing is that government have purchased some patents, and these patents made free to the public to install their industry to avoid the investment of a person in the intellectual part. Let us see, there are two questions. We can answer these questions. First question is on your screen. Can we patent coronavirus COVID-19? From last 2 years, we are suffering, means world is suffering with the coronavirus. There may be question in all mind that can coronavirus or COVID-19 is patented? Legally, there are two answers. Coronavirus COVID is non-patented because of this legal assistance. First thing is that as per the patent rule, those who are published known to the public cannot be patented. So the literature on coronavirus is available in the zoology research journals in the year of 1962-62. So it is a known thing, it is published in 1962, so it can be granted because it is not new. Only we are suffering, so that we are just discussing on the coronavirus, otherwise there is no need to use this question here. Secondly, can we patent your name? We cannot patent our name. If it is new one, innovative one, or complete new one, then we can get benefit of doing copyright of our name. So coronavirus cannot be patented because it's not new and it is not it. And second thing is that any live element cannot be, any live species cannot be patented. So coronavirus is a live species, so it is produced naturally and is growing naturally. So we cannot file the patent on the coronavirus. Now, if the academic institute, we all are working in the academic field, so that it's important to know the academic benefits of the intellectual properties. First is that our innovations can be protected by the IPR. IPR protects our innovation. It's the very good thing for academicians to protect our innovation. Secondly, the author of the patent or institute gets reputation because of the innovation. If some professor or some student filing more and more patent, the reputation of that institute naturally increases. Thirdly, IPR attracts the potential buyers. Means if you are having patents with you, then the industrial persons can contact you to buy your innovation for your financial benefit. This is the benefit of that patent. And important thing is that the ranking of our institute gets increased if you file more and more patent. In the map of the India, if you see some reputed ranking of that institute, that depends upon patent or filing intellectual properties. And main benefit that we can transfer our basic research into new innovative product, useful product. These are the academic benefits of the filing the patent. Now in the last part, I would like to quote here an example. It was the period of 1980, where 1980 to 85, where Hero Honda CD100 came in market. At that time, the running bikes were Rajdoot, Java, SD, Bullet. At that time, and still they are working, but they having the average, very few average. On this background, Hero Honda company modified innovatively the engine design, and it produced the most fuel efficient design, giving an average of 65 to 75 kilometer in a liter of the petrol. So it was a very huge change from Rajdoot, Java, SD, Bullet to the Hero Honda. So the innovation of that Hero Honda is granted for a patent with an advertised fill it shut it and forget it. Means if you fill the tank of that Hero Honda, you go miles and miles away without worrying about the fuel. So it was the advertise of that Hero Honda. And similarly, I would like to relate analogy. This advertise, I would like fill it. We have to think it innovatively. We have to draft it, and we don't forget to file it. So every researcher who or she is innovatively producing or publishing some research papers, they try to find the potential of filing patents or creating some intellectual properties. You get definitely an intellectual property, a clue in that for filing a patent. Thanks to all of you, those who are listening me from here more than 1 hour. Thank you to Principal Sir, thank you to the organizing committee, and thank you to all the participants, those who are joined here. Now the session is open for the discussion.
Any questions? No. Okay. Thank you, sir. Dr. Betkar sir has enlightened us the different types of intellectual properties like copyright, patents, etc. He has also discussed in detail the process of filing the patents. I'm sure that all the participants will be inspired by his ideas. Thank you, sir. Thank you so much again. Now, I would like to request to Dr. M.K. Gurme ma'am to propose vote of thanks. Please, ma'am.
I consider
Please
it a
wait
great
and
privilege
announce to
for
participant to discuss, as like our principal sir suggested that session should be interactive. You don't close at first thanking vote of thanks. You just wait. Someone is trying to unmute. Someone is asking to questions.
Okay, sir.
So myself, Dr. Vijendra Chaudhary.
Yes, welcome.
Sir, I am also working in material science.
Yes.
And if we are interested to register our patent in some experimental work.
Yes.
So in the experimental work, we have a different techniques and methods. So shall we register in that only, or what should we have? We have to show the new invention in that.
If your process is giving a new innovative product, then you go to filing the product as a patent. And if the product is already synthesized by other researchers and filed the patent, then you claim your process. As in my lecture, I have said that if there is single product, but process is different. First of all, you have to search your product on the patent. If there is patentable, then nothing use of that, so that you can file your synthesis process, practical process for filing the patent for synthesizing that material.
Okay. Thank you, sir.
Okay. Participants are requested to unmute themselves and ask questions. Otherwise, organized committee will go to express the vote of thanks. Okay, madam, continue.
Okay. I consider it a great privilege to propose a vote of thanks on this occasion. First and foremost, I would like to express my gratitude to our principal and the president of today's program, Dr. J.S. Dargad sir, for providing encouragement and enthusiastic support that help us all to achieve the best. I would like to extend special thanks to Chief Guest and Resource Person, Dr. M.M. Betkar sir. Sir, we are really enlightened with your knowledge on IPR and patent filing. Thank you, sir. Thank you for joining us online and sparing time from your busy schedule. I express thanks to Principal Dr. S.P. Gaikwad sir, Dr. Solonke sir, Dr. Bumrela sir, Dr. Satpute madam, and Dr. Nathani Madam for being with us today. I extend a very hearty vote of thanks to our Vice Principal, Dr. S.S. Bellari sir, for his presence. I am also thankful to Dr. C.S. Swami sir, Head of Botany Department, Professor Arne sir, for their constant support. I extend a very hearty vote of thanks to all the participants who blessed us with their online presence. I also extend my thanks to Mr. Sachin Patange and Vishnu Nayakpade and Rohini Shinde Madam for their cooperation in technical arrangements. I am also thankful to all teaching and non-teaching staff of Botany Department. Now, with the permission of President of this function, I declare that this function is over. Thank you.
Thank you, madam. Thank you.
Thanks.